Good morning. My name is Syed Afaq Hassan. This is a land law presentation on Land Registration Act 1925, now 2002, need for reform, particularly overriding interest. History of Land Registration Act. In order to reform feudal system, which was existed at that time, Law of Property Act 1925 was introduced, as well as number of other legislation including Land Registration Act 1925 and Land Charges Act 1925. The aim was to modernize the law of property and to simplify conveyancing by having all information relating to land in one central place and to ensure all title to land in England and Wales to be registered. Land Registration Act 1925 introduced the system of registration of legal estates and interests. However, the legislation had faced many criticism in relation to the existence of long list overriding interests, particularly the problems associated with Section 70, subsection 1 of LRA 1925. It was noted that by the Lord High Chancellor that LRA 1925, badly drafted, failed to provide proper framework for e-conveyancing, and as a result it was unnecessarily complicated. The shortcomings of LRA 1925 legislation was highlighted in Law Commission report, which expressly stated that LRA 1925 had failed to meet many of the objectives and made recommendations for further reform to the LRA 1925. Because of the problems, reform was considered and LRA 2002 was enacted. The aim of the LRA 2002 has always been that purchasers should only be bound by what is reflected in the register. The fundamental objective of the LRA 2002 is to ensure that there is certainty in disposition of land and purchaser is free from any burdens following the disposition. In order to give effect to this, the LRA 2002 was based on three key principles: mirror principle, curtain principle, insurance principle. These principles provided some assurance to parties that they are aware as far as possible of interests affecting land, thus no surprise post sale. Mirror principle. The first principle is the mirror principle, the idea that the register provides an accurate and complete reflection of property rights in relation to a piece of land. Curtain principle means that certain interests, such as beneficial interests, under a trust are kept off the register, which means the purchaser will need to know of them and overreach these interests. Curtain principle has been considered as crack in the mirror. Finally, insurance principle means that the onus is on the state to accurately record information relating to land, and any error on the part of registrar, the state will guarantee damages under Section 58 of the LRA 2002 to those who may have suffered loss as a result of an error. How do they ensure compliance with mirror principle? To ensure that all information relating to land is registered, LRA has made provisions and mechanism in place, either through voluntary registration or through compulsory registration when certain trigger events occur. If the trigger event doesn't happen, then the land can remain unregistered, which is effective considering that the aim is to create an accurate reflection of all interests to be in one place. Section 27 of LRA 2002 deals with any transfer of the registered which will be legal freehold or legal lease of over 7 years, or which does not take effect in possession until at least 3 months after grant of a legal charge, and express grant or reservation legal easement. On the transfer of freehold estate, on the grant of lease of more than 7 years, on the transfer of a legal lease with more than 7 years to run, the estate owner must apply for registration within 2 months of the transaction, otherwise transaction becomes void according to Section 4 of LRA 2002. Section 29 of LRA 2002 clearly states that a new purchaser will be bound by any notice that appears on the charges register, as well those interests which are overriding interests as listed under Schedule 3 of LRA 2002. Overriding interests. Overriding interests are third-party interests that are binding on a purchaser even though they are not protected by an entry on the register. A list of overriding interests that override registered disposition is given in Schedule 3 Para 2 of the LRA 2002. Overriding interests are major shortfall of both LRA 1925 and now 2002. The existence of overriding interests which are invisible but nonetheless bind the purchaser is in Para 1 deals with leases less than 3 years, Para 2 deals with rights of a person which is in actual occupation, and Para 3 deals with implied legal easement. Why do we have overriding interest? The category of overriding interest exists because landlord recognizes that there are circumstances in which it is unreasonable to expect a person to register his or her property right to secure his priority or enforcement. The existence of the category reflects a policy decision that in some circumstances the desire for the register to provide a complete and accurate picture of the right existing in relation to a piece of land should give way to a countervailing need to protect such person's right. The question is, what amounts to actual occupation under Para 2 Schedule 3 LRA 2002? The most controversial category of overriding interest is found in paragraph 2 of Schedule 3 LRA 2002. We can summarize it by saying that a purchaser will be bound by a property interest of whatever kind of someone who is in actual occupation of the land. The Para 2 of the Schedule 3 LRA 2002 caused much concerns, even though it has seen much reform following the concerns that was faced under Section 70 of the LRA 1925. The following includes some of the features illustrated by case law. There has to be physical presence rather than some entitlement in law. Case reference Williams and Jennings Bank Limited and Brown. A degree of performance and continuity. Case reference Abbey National, BS and Ken. Effect of temporary absence can be seen in choker and choker. Conditions to be satisfied in Para 2 are: the person with the interest, if asked about it before the purchaser bought the land, didn't fail to disclose it when she could reasonably have been expected to disclose it, and the person's occupation would have been obvious on a reasonably careful inspection of the land at the time of the disposition, or the purchaser had actual knowledge of the interest at the time. However, purchaser can avoid being bound even if Schedule 3 Para 2 conditions are satisfied, in the case of City of London Building Society and Flag. It was established that overreaching beats overriding. Is it the time now to abolish the overriding interest? The mere fact that overriding interest still exists means that objectives of LRA are not met. Nonetheless, LRA 2002 has restricted the rights of those who are in actual occupation, although it is still capable of being created. Although purchaser can avail himself protection by carrying out inspection of the land, the point is that it still has not been completely removed. The Law Commission had the opportunity to abolish the infamous Section 70 and long list of overriding interests, but instead of completely abolishing it, reduced it to 3. The existence of these non-visible interests of third parties goes to the core of the problem faced by LRA 1925 and now 2002. It is a barrier in achieving the goals and vision that was envisioned by the drafters of having all information visible in one place. The very fact that these interests which bind the third party do not appear on the register means the purchaser continues to having to make inquiries and investigations. So therefore, we need some reforms. I'm suggesting abolish overriding interest. There is still unnecessary risk for the purchaser as the area of overriding interest creates uncertainty and surrounds many hurdles he needs to get through in order not to be bound by overriding interest of those who are in actual occupation. By abolishing overriding interest, LRA 2002 will provide the protection to the purchaser as it was envisioned. The objective of LRA will be achieved as the whole objective was to get away from this situation when reforming LRA 2002 was, but very little has been achieved so far. In conclusion, potential purchaser still need to make sure and establish whether there are any third-party interests that may bite him. But on the other hand, if the LRA 2002 was to create a strict system, there may be people who are left vulnerable at the same time. The purchaser still has been given the opportunity to discover existence of overriding interests which could be balanced as it needed to protect both parties. However, it will be apparent from the overview that land registration is a complex and technical matter. The law is correspondingly difficult at this moment. It is an indication that the law is in need of reform. Land registration has to take into account the different property rights that exist in relation to land and determine, in respect of them, whether and how they should appear on the register and what should happen when dispositions of the land or first registration take place. When we buy land, we need to know exactly what rights we will have and who else may have rights that impact on our use of the land. We place significant reliance on the register to provide us with that information. The law of land registration is important as it affects all of us in the rights we have in our land, whether we own or rent the land, whether the land is our home or our business. Effective land registration law underpins the smooth operation of the property market, which is essential for the health of the wider economy. Therefore, since we have established that overriding interests are biggest problem, so they should be abolished, and to conclude, LRA 2002 should be reformed as it is complex and difficult at the moment. That was the end of my presentation. Thank you.